This is part 2 of a 3-part series on public records. In part 1, we covered what a public record is and who's the custodian of public records. In this video, we'll cover the basics of answering public records requests. Part 3 will address how long public records must be kept. Any person of the age of majority may inspect, copy, or reproduce any public record, and any person, even minors, may obtain a copy or reproduction of any public record. The law limits the definition of person to exclude individuals in custody after sentencing following a felony conviction who has exhausted his or her appellate remedies. When the custodian receives the public records request and the records immediately available, the custodian has the duty to provide the requester with the record. If the record is not immediately available, the law requires that the custodian promptly certify in writing to the requester 1. The absence of the record and the reason for the absence of the record from the custodian's custody or control. 2. Current location of the record. 3. The person who has current custody or control of the record. And 4. The exact time at which the record was taken from the custodian's custody or control to the best of his or her knowledge and belief. The custodian should provide the date and time the record will be available for copying or inspection to the requester. If the custodian has a question regarding whether or not the requested record is a public record, the custodian must, within 5 days, exclusive of Saturdays, Sundays, and legal public holidays of receipt of the request, notify the requester in writing of the custodian's determination. The LLA strongly recommends that any such determinations and written notifications should be done in consultation with your attorney. The Public Records Law provides for penalties and fees, including attorney's fees, for the improper denial of a public record. However, custodians will not be held personally liable for attorney's fees and other costs when he or she withheld records on the advice of legal counsel. The written notification must contain a reference to the basis under the law that the custodian has determined exempts the record or any part of the record from inspection, copying, or reproduction. You can go back to part 1 of this series where we talk about exemptions from disclosure. When part of the record is exempt from disclosure, the custodian should redact that information from the record before providing the record to the requester. The custodian should provide the date and time the redacted record will be available for copying or inspection to the requester. The law provides that no fees may be charged for the examination or review of public records. However, the law provides that the custodian may establish and collect reasonable fees for making copies of public records, which includes the transmission of electronic copies. The key word here is reasonable. The custodian of public records for a local government entity shall establish a reasonable fee schedule and post a schedule where it can be readily accessed by the public. The custodian of public records of a state agency shall charge fees for copies according to the uniform fee schedule adopted by the Commissioner of Administration. For additional information, please review the LLA's FAQ on public records law, located on its website at lla.la.gov. Learn more by visiting the legal FAQs at the Legislative Auditor's website at lla.la.gov. This video is for informational purposes only. It is not a substitute for legal counsel. Please consult with your attorney before making any decisions.